directors board meeting to discuss the investment. The legal advisor informed the company that the regulators have made inquiries about the investment, particularly the possibility of related party transaction. Minutes of the board of directors showed that the directors unanimously agreed that there was no conflict of interest, agreed with Baba's recommendation, and authorized Baba to finance the contract. Unfortunately, PECBIS suffered loss due to LMN's mishandling of the investment. Due to Baba's advice, the board agreed to negotiate with LMN, but the contract was finally terminated in May 2022, calling losses to PECBIS. LMN also filed a suit against PECBIS. Baba has been asked to take leave from the company, and 3 new directors were appointed to PECBIS board. The new board's investigation discovered that LMN was incorporated by its founder due to Baba's request that Baba was signatory to LMN's accounts prior to PECBIS investment, and that 2 of LMN's by its founders due to Baba's request that Baba was a signatory to LMN's account prior to PECBIS investment, and that the 2 of LMN's directors were his nominees holding shares in LMN on behalf of Baba. The investigation also found that there were instructions given by Baba for consultation fee to be paid to a firm controlled by Baba's girlfriend. Invoices sent to PECBIS were also allegedly false and issued under Baba's instruction. Baba denied that the allegation stating that the relationship with Ain was not a family relationship that could give rise to conflict of interest. He has received a huge inheritance and decided to retire from the company. At the board meeting on March 1, 2022, she tendered her resignation to be effective on July 1st, 2022, in accordance with her employment contract. She informed the board that she was still unsure what to do after her retirement. From March 1st, 2022, she took leave with the board's approval and was not involved in any board meeting to ensure confidentiality of complex affairs. In June 2022, Lily decided to incorporate a company, although she has not decided what business she wants to carry out. In mid-June 2022, several of PECBIS customers contacted Lily, and after this customer were informed that the company would not be supplying them with the product from December 2022, as Lily was well liked at PECBIS. Several of his employees informed her that they would like to work for her, but she advised them to join her after the expiry of their contract of employment. From October 2022, Lily launched her own business manufacturing similar products and sold them to some of PECBIS customers. Since Lily's business was a success, PECBIS was of the view that Lily had used information about the customer and pricing strategy and had diverted the company's business. At a trade exhibition in March 2022, Sam met a representative of Ecopax Limited, company that was interested to invest in Malaysia to produce and market biodegradable, environmentally friendly packaging materials. For some time, Sam has suggested the PECBIS and each venture into manufacturing biodegradable packaging. After returning to Malaysia, Sam presented his views about joint venture with Ecopax, and the board authorized him to negotiate with Ecopax. However, in June 2022, after securing Ecopax agreement, Sam was disappointed when the board of PECBIS told him that they were not keen to enter into the agreement with Ecopax due to the substantial capital investment that PECBIS will have to incur for the expansion plans. Sam then introduced Ecopax to Lily in August 2022, and Ecopax signed the agreement in November 2022. However, in October 2022, PECBIS decided to diversify into green packaging. Sam immediately resigned, stating that he was frustrated with the board's indecisiveness and joined Lily's company. PECBIS was of the view that the business opportunity provided by Ecopax should not have been diverted to Lily. Advised PECBIS whether there has been any breach of duty to avoid conflict of interest under Section 221 and 218 of the Companies Act 2016.
Ini last semester punya soalan.
Yes.
I think panjang.
So the question asks us to advise on whether there is any breach of duty by Baba or Lily or Sam to avoid conflict of interest as in Section 218 and Section 221. Okay, firstly, in regards to Baba, whether Baba has reached his duty using his position as a director to promote his personal benefit. So according to Section 218, Section 1, Paragraph C of Companies Act, a director or officer of company shall not, without the consent or ratification of general meeting, use his position as such director or officer. Means that without consent or ratification of general meeting, among others, the director cannot use his position as a director or officer. So according to Aberdeen Railway Company in 1854, in this case, the company entered into contract to purchase equipment for partnership very gross. However, the director did not disclose that he has interest. He was a partner in Blakey. So he had breached his duty by placing himself in position where his personal interest might conflicted with his duty in the company. So in Regal Hastings Limited and Gulliver, 1967, the court, in this case, the Regal wanted to acquire the leases of two cinemas, and they incorporated, amalgamated the subsidiary or incorporated, amalgamated to hold the lease. However, then the owners of two cinema then requested it should pay up capital to be £5,000. A issued further shares at £1 each, and then after the issuance of share has been given and they have acquired the lease of the two cinemas, then they sold the shares and made profit more than the shares. The amount they gain the profit from the sale of the shares more than £2 per shares. So the court held that the four directors has actually reached their duties, taken an opportunity to make a profitable investment by selling their shares, and has resulted by the sale resulted the shareholders in illegal receive reduced proportion in Hastings amalgamated. So means that they use their position as director to gain the benefit, and that cause the losses to the shareholders. However, the court decided even there is no losses, they still liable. It doesn't matter if they gain the losses or not. In the present case, Babies Berhad was induced by Bapa to a business opportunity in Indonesia involve they have to purchase 35% shares of LMN. It was found that LMN's incorporation foundation was Baba's request, and he was a signatory to LMS. And he also put shares. Two nominee directors in LMN had shares on behalf of Baba, and he had used his position as a director to induce Babies to do business to purchase share in LMN. So by his position, inducing the boards of Babies to do investment with LMS, he had used his personal his position to promote his personal benefit as a persons that hold such high position in LMS. So, however, after the Baptists has invested in the LI, they have incurred losses, and due to the suggestion and option that has been made that has been suggested by Baba. So, by using his position as director in Baptist to induce and to, as a director, he had discussed about whether to do the investment. He has put himself in a breach of fiduciary duty to protect the interest of Baptist, and he has gained benefit in his personal benefit, and has put jeopardize to the interest of Baptist for his personal benefit. So Baba has committed breach of fiduciary duty using his position as director to gain personal benefit, personal interest. So, next.
Maybe I think you should also get your education. You should take the case in your education as well as take the section which says that this is the decision will not benefit from that where Mama or the company. In others, maybe when we say that it resulted the company is on the loss to the invest. So that you can refer as the section says. Although it's all what it happened here. Okay, so you can say that it is as discussed or as restricted in the decision.
So next issue, whether Baba has breached his duty by failing to disclose his direct or indirect interest with contract entered by Pet Bids Berhad. So we will look into the conflict of interest in regards to Baba's position, signatory to LMS account, and Baba's relationship with Anne, his girlfriend. In this present case, Baba has instructed the consultation fee to pay to a firm controlled by his girlfriend, Anne. So whether that the amount of conflict of interest.
Tapi yang interest in the disclosure here is not only pasal but the security, I think, but you shareholder order with someone else guided on but shares on his income. So there are share this qualified with this around 1.1. So I know you can follow it for situation and two different solutions. Can because the second one, your girlfriend has nothing to do with and
So, according to Section 221, Subsection 1 of the Companies Act, subject to this section, every director or company who is in any way, whether directly or indirectly interested in a contract or proposed contract with the company, shall as soon as practicable after relevant facts have the director's nomination declare the nature of his interest at the meeting of board of directors. Means that if he had direct or indirect interest with the contracts and with the company, he had, as soon as practicable, he had to disclose his interest at the meeting of the board of directors. In the case of Magnifying Syndicate Berhad and Yap Moon Hin, 2005, a managing director was responsible to purchase resales to company, and in this, he received commission, but he failed to disclose the commission he received. Richard Balajan judge says that, as he said, as a fiduciary, the defendant was obliged to make a full and frank disclosure of not only the fact that he was being paid, but also as to the amount. Indeed, even a full and frank disclosure, the non-conflict rule, the non-profit rule, is that he has to make a full and frank disclosure. So next slide. So in the case of Yo Gyap Singh, I'm public prosecutor in this Singaporean case. Yo was managing director of MFD and also a director of SMS, and also a manager and shareholder of 50% in Triple Star. In this case, the MFD was awarded a contract to put a community center Yo on behalf of the company, and take the contract awarding the construction to the SMS, and also he had the consultation fees paid to MFD were deducted from the SMS account. In this case, the Triple Star also supplied building materials to SMS. However, he had failed to disclose his interest with MFD and also his interest in Triple Star. The failure to disclose his personal interest in MFD and Triple Star had mounted to breach. So next, in another case, Transvaal Lands Company in New Belgium. In this case, Samuel was a director of New Belgium before Transvaal, and he was authorized by the board of New Belgium to offer to sell to Transvaal some shares of New Belgium shareholding company. However, the Transvaal later found that Samuel was a director instead of agent. He was a director and shareholder of New Belgium. And beside of Samuel, there is also Harvey among the directors, also had shares in New Belgium as a trustee, which the beneficiary of the trust is his wife. So Samuel and Harvey was held to be to breach their fiduciary duty because they both of them had the personal interest. The Harvey because he holds the shares on behalf of his wife, and Samuel because he was a director of the shareholder of New Belgium, but he failed to disclose. So the failure to disclose his interest amount to breach of duty. So in section 221 subsection 1 of Companies Act, so for the purpose of this section, an interest of the shares of the or debenture of the company may include the spouse, the interest he hold for the spouse of a director who is the spouse must not be a director, and also the interest linked to a child, including adopted child or stepchild, or a director of company of a director who is not a director of the company. So application to A in regards to Baba's position, as he has shares in LMS. The back bits firstly, in the present case, the back bits was induced by the suggestion by the Baba to invest in the LMN, but then was found that he also had the shares in the LMS, but he failed to disclose. Although there was a minute meeting that decided there was no conflict of interest, but he failed to disclose to the board of directors in the meeting that he had the shares. So the failure to disclose that his interest in the LMS, holding the shares in LMN, so he had caused the breach of duty as to disclose his interest. So next slide.
As required by section 21 subsection 8. Your application is for me is put a light on your reference by referring to the case. Then macam you apply to that model like but by the end of the
Okay, for the Baba's relationship with Ed, Baba had instructed consultation fees to be paid to a firm which was controlled by Ain, his girlfriend. It was alleged that the invoice sent to the Babies was false and issued under Baba's instruction, and Baba had denied the allegations that the relationship with Ain was not a family relationship that could give rise to conflict of interest in accordance with Section 221 and Section 221 subsection 9, which includes that they have to disclose the interest, and also includes the interest that might be related to the spouse, which is not a director to the company. Whether a girlfriend can be considered as a spouse under Section 2219 subsection 9, paragraph A. So there is no definition given in Companies Act, neither in interpretation as what amounts to spouse, whether it only inclusive wife that has legal marital relationship or with any person that has intimate relationship. Referring to paragraph B, it refers to of a child, including adopted child or stepchild, means that show that children that have such fiduciary relationship with the person compared to other types of children, means that they have such relationship that makes a person have a fiduciary duty to compared to other types of children, means that any children compared to other child like adopted child, stepchild or biological child, they have like a stronger relationship. So next slide. So compared with paragraph 5,
the statement a girlfriend is similar to what? Can be manipulated by the boyfriend. The girlfriend macam wife atau wife what is girlfriend what
I would like to submit that a girlfriend can be like a wife relationship if they can prove that they have such fiduciary duty, such fiduciary relationship that if there is confidence that he will act in the best interest relationship if I
Kalau misalkan just to explain regarding the close relationship in other technically because section 1 subsection 9 had highlighted that wife they are included in this section, so you can widen the scope by anything like any person who is in a close relationship. In a way, a close relationship can be like friends. Not necessarily the friend. So therefore, tapi dia nak kata how you have to influence by in that case we can be quite partners. apa saya ni just show kalau nak argue macam-macam pasal sebab dia say that dia like in a way dia memang first sekali dia can say that
So his relationship with Amani had a relationship with my conflict with interest as a director of the benefits. So applying to the transfer land case when the director has interest of shares when his wife was a beneficiary of the trust and the relationship is kind of similar where they might have intimate relationship. They might conflict with the duty as director. So by not disclosing the disclosure of the interest that he had with and also the failure of Baba to disclose the fact is that he had interest as a shareholder in LMS. So he had failed to disclose his interest and that had amounted to breach as required to section 221 subsection 1, which requires him to disclose the personal interest that related to contract entered by the contract. So, in conclusion, that Baba has committed breach of duty to his failure to disclose such interest, that investment contract with LMM and also the interest to the end because because she is the girlfriend of Baba was control the firm. Yes.
Okay, regarding Baba, there is something that if you refer, it says that the investigation also found that there were instructions given by Baba for consultancy to be paid the full control by ends. So in other comments regarding that particular by the sebab when you discuss about disclosure just now, although dalam first tak mention, dalam first just mention, there is that investigation found out that Baba is subject to pay for consultation with a firm control by M. So in other words, you can see that there is a contract between the company and M, right? So in a way, that's what you want to establish, that one disclosure from Baba because of his relationship dengan M and to friend. Can you what is you must disclose when the company has a contract. I mean, when you have interest in a contract between the company and the company, you ada contract satu. But here at the same time, yang tu satu pasal disclosure. Because the one is merely disclosure. Okay, towards the end of the understand is a situation whereby dia ada either business position, it's a company property, whatever not. So here, dalam fax dia kata, dia suruh bayar, dia suruh the company pay ends and firmkan the firm to provide ends. So in other words, that is misuse of the company property. So it's by okay, so that is how we nampak tak? Kata nampak?
Misuse.
Misuse lah sebab it's not invoices sent to factors were also eventually false and issued under Baba's instruction. Macam yang kita. So in other words, it shows that like you hire that one it seems to be the contract. Maybe you can say like maybe such a side the government hired it. Sebab Baba instructed all those like policies are false under this instruction. So then like relating to that, we can see that we have misuse of the company property in the sense that the money is paid.
So our next issue is whether Lily has breached her duty by using the information she gained from her former position. So just a quick recap. Basically, Factors was of the view that Lily had used the information about the customer and the pricing strategy. So in March, Lily tendered her resignation and take leave so that to ensure that confidentiality is protected. And then in mid-June, the customers were the ones who contacted Lily after they were informed that that Packmates would stop their supply of product from December onwards. And in July, Lily's resignation was effective, and in October, Lily launched her business, manufacturing the same product, and she sells them to some of Packmates customers. So if we refer to section 218, subsection 1, paragraph B, which says that a director shall not use any information acquired by virtue of his position as a director of the company to gain a benefit for himself or to cause detriment to the company. And this duty has been established in the case of Botman against Phipps, which this is actually a case of trust, but what is established here is that a profit that is made from knowledge gained through fiduciary duty is a breach of such duty and amounts to conflict of interest. And the court says that the end result was that out of this special position in which they were standing in the course of the negotiations, the appellants got the opportunity to make a profit and the knowledge that it was there to be made. So even though in this case actually, the appellants did not make a profit for themselves only, the profit that they made was for themselves and for the trust, for the beneficiaries of the trust. But because he is a trustee, he is a solicitor for the trust, he cannot use that position in order to gain benefits for himself. Next, please. So basically, the duty is to not impart corporate information. So what is considered as corporate information? In the case of Ascenda Chicken against Fowler, they distinguish three types of information. The first is that it is not confidential because of its trivial character or its easy accessibility from public sources. And second, it is confidential only while he is in position. That can be either because the information was given in a way that it is told that it was confidential, or because from its character, it is obvious that it is confidential. But once he leaves the company and the information remains in his head, it becomes part of his skill and knowledge. So it is no longer confidential once he leaves the company. And the third type of information is that it is always confidential, which are specific trade secrets so confidential that even if they learn it by heart and they have left the service, it cannot be lawfully used for anyone's benefits but the company's. Next, please. So, in this case, we can clearly see that, of course, customer information and pricing strategy are definitely confidential while he is in position, because the character itself can be considered as a trade secret and its information can negatively affect the company's business. So right now we want to see whether it falls under the second category or the third category, whether it falls under what is considered as the director's skill and knowledge. So we refer to the case of advanced fuels technology. In this case, Company A fails to win. Basically, there was a sort of like a tender. Company A and Company B both went for the tender, and Company A fails to win the tender, partly because the director from Company A has resigned and joined Company B, and his established personal reputations convince the person giving the job to give the job to Company B. However, when the court looked at the facts, there was no proof that the director has any improper use of information. Instead, even though the Company A actually quoted for the job while the respondents were still working for a company, while the directors were still working for Company A, from the facts, it shows that what attracts the job offerer to Company B was the director's established personal reputation, partly while he was working at the company. Next, please. And so now we look at earlier we look at like strategy or his skills as a person. Now we look at contact details. We're referring to the same case. In this case, even though the respondents did acquire the contacts of the clients while he is working at Company A, it still does not amount to confidential information because these are just names, email addresses, and telephone numbers. and the list in which the list of contact details in which the respondent was, or the director was referring to, was in the phone that he used while he was working with the company, and that includes information which is available through public sources as well as his own personal contacts. And while some attributes of the data can be seen as confidential, and the manner of creation can be seen as confidential because it was made while he was working at the company, on the balance of probabilities or facts, it seems to lack the quality that it is completely confidential. And it is unlikely that the respondents here would have been unable to remember their contacts or be unable to contact most of the customers and the suppliers they worked with, even without their contact details. It just makes it easier for them to contact them. And it also shows that the facts also shows that Company A was not deprived of the ability to still communicate with their customers and suppliers simply because the respondents retained a copy of that data. Next, please. So right now we want to see, basically in the case earlier, you can see that the two, it just happens to be a coincidence that they won the jobs because of his position as a director. First, because he happens to work there previously, and so because part of his knowledge and skill. So now we want to see whether it is just a causal connection, or is this a coincidental concurrence. In the case of Waldron against Green, Mr. Green here is a director of Company A, and while he was working, and he is also a director and majority shareholder of Company B. So while he was attending a meeting at Company A, there was a decision made in which the effect of that decision was that Company A's shares will be reduced. The shares value will be reduced. So in between the period of that meeting being held and before they could actually do the act which reduces the value of the share, Company B sold their shares of Company A, because Company B also has shares in Company A, so they sold the shares of Company A, and so Company A sues Mr. Green, saying that it is done because Mr. Green's information of knowing that Company A is going to reduce the value of the shares, Company B has sold their shares. However, in looking at the facts, the Supreme Court held that the magistrate here was correct actually to dismiss the prosecutor's charge, because even though there are all of these concurrent events, there is actually no evidence that Company B's selling of shares was actually due to Mr. Green's position as director of Company A. Instead, there are evidence that Company B's liquidity problems is actually what causes them to make this business decision to sell the shares of Company A so that they would not go into debt. Next, please. So in the case of, in order for us to establish causal connection, the case Coco against Anne Clark states that there are three elements which you have to establish in the case of a breach of confidential information. The first one, the information has to have necessary quality of confidence. The second, the information was imparted in circumstances that enforce an obligation of confidence. And the third, there was an unauthorized use of that information to the detriment of the party communicating it. So in this case, the court says that the second element was proved because the plaintiff did show the information here is a design of their product, and the way they talk about the design, of course, the design was to be a trade secret. However, the plaintiff fails to show that their design is actually original and thus making it confidential, and the plaintiff also fails to show that the similarities in the design between the companies and the company that the director later moved to was actually coming from the information which was communicated while he was being a director in Company A. And so in this case, since only the second element was fulfilled, the directors were held to not be in breach of confidential information. Next, please. So, if we go back to Lily's case, did Lily breach her duty? We have discussed earlier on the quality of confidence, and there is no evidence that she uses the same strategy, even if the same pricing strategy in her company now compared to what company A had compared to what Packbits has done earlier. And so, even if the strategy is similar, because of the lack of evidence, it has likely become part of her skill and knowledge. And the contacts the contacts as well has already become part of her personal contact. And this can be proven by the fact that the customers were actually the ones who contacted first, not Lily. And for the second element, the circumstances did not import an obligation of confidence, because she is only obliged to keep those information a secret while she was the director, and there's no evidence to suggest that she was under contract that says that she cannot do this, she should not contact them after she is a director, etc. And for the last element, there is also no evidence to suggest that there is an unauthorized use to the detriment of the party communicating it. For the pricing strategy, there seems to be no evidence that she used the strategy at all. And for the contacts, the use was not unauthorized. She did not initiate the contact with the customers in mid-June, and actual business arrangements was only made after she had resigned in July. Next, please. And to distinguish, we want to refer to the case of Southern Real Estate Privately Limited. In this case, the director prepared her list of clients before she resigned with the intention of using it once she resigned. And she had posted and delivered letters to the clients informing of her departure the immediate day after she resigned from the company. And not only that, she did resign with the purpose to establish business in direct competition of the company, and she purposely did not inform the board of her intention to resign so that they have no time to react and find a replacement. And only a week later, the first company here, the appellants, Company A, received notice that their clients are terminating their contract. So we can see from all the facts that it is a carefully orchestrated plan to place the appellants in real difficulty to compete while she was still acting as a director. And there are other facts, such as she has already prepared letterheads, she has already prepared machineries. So all of this shows that this plan was carefully orchestrated, and she was, while in the process of doing that, she was collating information for use as a competitor. Next, please. Sorry, madam. So, if we can see from the case that the customer did initiate it, I think need that covered at the okay, next. So, last issue, whether Lily and Sam has breached their duties as directors by diverting corporate opportunity. Next. So, this is just a recap. So, mula-mula Sam suggested that they should be treated to biodegradable, and then in March, he had presented his views about, he had met Ecopax and then presented views to Ecopax, Packbits that they should join a joint venture with Ecopax. And at the same time, Lily tendered her resignation and took leave. In June, Sam secured Ecopax agreement. The board of directors of Packbits told him that they were not keen to enter into agreement, and so at the same time, Lily decides to incorporate a company, but she hasn't actually decided on what the business should be. In July, Lily resigned. And in August, Sam introduced Ecopax to Lily. In October, Packbits decides to diversify into packaging. Sam immediately resigns and joins Lily's company, and in November, Ecopax signed agreement with Lily's company. Next, please. So, referring to section 218, subsection 1, paragraph D, it says that a director shall not use any opportunity of the company which he became aware of in the performance of his functions as a director of the company to gain directly or indirectly the benefit for himself or any other person or cause detriment to the company. So in this case of Wilkinson against West Coast, basically the court says that if a fashion clothing company is actively considering diversification into distribution of farm machinery, then yes, there would be a real sense of possibility of conflict in a director-taking state. And he can only escape that conflict if he resigns as a director. Next, please. So the question here is, did Lily divert business opportunity? And from the basically, all of this Lily's decision making in regards to her new company was made after her resignation was official, after which her duty was ended, and even before that, when she incorporated a company, and she has decided what company to be yet. And in mid-June, some of the customers contacted Lily. She was already taking leave, and she was no longer attending the company meeting. So Lily did not in any way divert any business opportunity here. However, the question for Sam is harder. Did Sam so first we want to look at whether Sam divert maturing business opportunity. In June, PacBiz was not keen to enter into agreement due to substantial capital investments that would have to incur. So PacBiz decided to diversify into green packaging only in October, but Sam introduced EcoPack to Lily in August, 2 months earlier. So PacBiz at that time, when Sam introduced EcoPack to Lily, was not actively seeking this opportunity. Next, please. So now we want to see if it is if the company is in the current line of business. We refer to the case of Bola against Bola. In this case, basically, it was in the company there were two families. I call them factions for simplification's purpose. And so one faction told the other faction, Mo's faction told Son's faction that they don't want the company to acquire more properties. So when a property next door became available, Sohan's son acquired the property without telling Mohan's faction that this property is available. So it was held that there possibly may conflict in fixed installments here means that a reasonable man would think that there was a real sensible possibility of conflict. And so the court says that it's not a question of whether or not the company could or would have taken the opportunity. The point is, the existence of the opportunity here is an information that is relevant for the company to know. So the appellants were under a duty to communicate it to the company. Next, please. So, is it under the current line of business? If a reasonable man, we argue that a reasonable man would think that there is a real sensible possibility of conflict, as biodegradable and environmentally friendly packaging is still a type of food packaging, a business of which PacBiz is actively engaging in. So even though PacBiz has yet to engage in green packaging, at the time when he introduced EcoPack to Lily, there is a real possibility that PacBiz might diversify and expand in that area in the future. And Sam has the duty to communicate the opportunity to the company, which he did. And in fact, he had pursued negotiations on the company's behalf. However, the company later decided not to engage with EcoPack due to the high cost needed. So, next, the question is, can he exploit the opportunity after the company has rejected? Again, the question will be whether a reasonable person, considering all the facts and circumstances, including the fact that the company has rejected, will find an actual or real possibility of a conflict of interest. In the case of Island Export, the director resigned from the company out of dissatisfaction with the company's progress and later received an order from the company's former customer. We can see that at the same time, the company was not actively pursuing further orders, either when he resigned or even later when he subsequently obtained contracts. So when a year later the company suddenly decides to sue the director, it was held that the director did not reach his duty. In the case of Robash against Gladstone Pacific, the third party approached the director before the director actually becomes the director of the company. However, when the offer was later repeated while he was already a director of the company, the director says, he is the director of this company now, so he cannot engage in this business personally, but his company is interested in joining in this opportunity instead. However, later, as it turns out, the company did not get the job, and only then he took the opportunity when he realized that it is no longer available to the company. And the court held that this is not in breach of his duty. Next, please. And lastly, I want to show the case of Peso Silver Mines Limited against Crawford. The board of directors of appellants in this case had rejected the offer to buy certain mines while the respondent was still a director. So later, the respondent was approached by a bunch of people and they decided to form a syndicate in which they can acquire claims which were first offered to the appellants, which the appellants had rejected. And the syndicate was formed, the claims was purchased, and then members of the syndicate formed a company to develop these property they have bought. Later, the control of the appellant board changed, and so this new board decided that dismissed the respondent and decided to sue the respondent because he had not disclosed his interest in the syndicate when he was buying these properties. However, the court held that the appellant has actually dismissed the offer for good commercial reasons, nothing to do with whether or not the appellant was interested in the business or not. And they themselves have decided that they have no interest in the mining claims. And the respondent was not in a position of conflict of interest and duty here because the appellant had made a good faith business decision to not buy the claims which the respondent later purchased. Next, please. Okay, this part is, I am not 100% sure about this part, but this is my argument and my advice to Packers. So, because Sam has encouraged Packers to venture into biodegrading packaging and actively seeks opportunity on Packers' behalf, and later he informed Packers of the opportunity and even negotiated with Ecopax on Packers' behalf, not on his personal behalf. And after he has secured the agreement for Packers, the board of directors told him that they were not keen to enter the agreement based on bona fide commercial reasons, the amount of cost they have to incur. And only then Sam introduced Ecopax to Lily. And we can also see that Sam's resignation was based on his frustration with Packers, nothing to do with his intention to start a new business or to divert a business opportunity away from Ecopax. So I would argue that it is hard for Packers to win a case in which they accuse Sam of breaching his duty. And Sam here has actually not breached his duty and diverted business opportunity away from Packers. And that is all from my statement.
And also you can see that when Packers say they are not keen, that warranted like they reject.
Sebab dia tak proper rejection, so that's where the issue lies. But I think from the facts and circumstances,
they already let go of that.
I use the argument yang a reasonable person tengok ada real sensible opportunity tak. So macam reasonable person would consider tak lah.
That no longer, because once like they are not, when they say they are not keen, that's it. Bila they are no longer wants to support that.
So the fact that dia tukar fikiran in October tak berkaitan.
They would like you can construe that as they rejected.
Oh, faham. Okay.
So therefore, like this.